Let me pick up on exactly the point that Delegate Norton just made. Given that the Latino vote is large and growing, and there's a perception that it is somewhat up for grabs right now in the country, would Republicans be wise to temper their attack, just to use a kind of shorthand word, against Sotomayor, feeling perhaps that if she's going to go through, don't harm yourself in terms of your long-term aspirations and prospects in terms of big picture national politics?
Yeah, absolutely. I mean, I think, look, the Republican Party is starting to look more and more like a regional party, of old white guys. So at this point, the question becomes for them, are we going to attack this woman? And again, what we heard in the precursor to this was, this is an issue of qualifications. Well, you can't attack the qualifications. If you look at the cases, you really can't attack the cases. You can disagree with the reasoning. You can do all of that. As a matter of fact, I've seen some web ads which have essentially said, well, she's been reversed by the Supreme Court of the United States. Well, who hasn't? And really, who cares? I mean, the question becomes really, as you look at this issue, they would be wise not to make political hay of this, and probably with all of the problems with Michael Steele and with Rush Limbaugh and all of those kinds of things, I'm not sure that this is the fight that they want to pick at this point.
Is that right, Ken?
There will be a political cost to pay if Republicans beat up on her too much. But the Supreme Court reversals did come in cases that divide on a liberal-conservative axis and on which she's identified with the liberal bloc. So judicial conservative advocacy groups are going to be there, are going to be faulting her on property rights, on regulatory issues, probably on criminal law some, and so there's going to be a debate, and of course she will be asked about the role of the judiciary. She will be asked about strict construction, a phrase that neither the president nor she used today. Okay, and so there's going to be another constitutional law seminar for us that conservatives will want to raise.
And I'm glad you brought that up. What do you guys think of this qualification requirement that the president added to the conversation when he talked about a nominee, in addition to having all the obvious things about legal experience and knowledge, having the common touch and a sense of how the real world works? That's a little bit of a lightning rod for some. Is that a valid thing for him to seek and maybe insist on in a nominee?
Yeah, I don't know. That concerns me. Because again, I don't know that really is the qualification. I mean, how does one define the common touch, and who gets to define what the common touch is? I think that is.
It could almost be code for rule the way we want the thing to turn out, as opposed to what.
Precisely, and so that I'm a little concerned about that.
Well, I think there will be groups and senators concerned about it. At the same time, it's kind of hard to appeal to the public and say this judge has the common touch and that disqualifies her.
Yeah, but the problem with the common touch issue, I mean, come on, if we're talking about the problem with the common touch is not Princeton and Yale.
So no, but it is Lilly Ledbetter.
Yeah, but it is Lilly Ledbetter. It is Lilly Ledbetter. But I mean, when we get to this whole conversation of common touch, I agree. I think certainly there is going to be, I think, debate on the issue, but the question becomes, do you overplay your hand? And I think certainly, just like if this were on the other side, liberals, conservatives rather, would have been saying, okay, so here's the situation, she's been reversed. Liberals would have said, if it were a conservative justice, the justice has been reversed. So certainly I think the strict constructionist debate has to be had, but again, the question is it pure strict constructionist debate, or is it strict constructionist debate really disguised as, political machinations? That's the question.
It's worth noting that in her remarks today, the judge, without using the word empathy, did say that because of her varied experiences, prosecutor, corporate lawyer, now federal judge, she was better able to appreciate the concern of all the litigants before her. So in a sense, she was saying, yes, I'll be empathetic to both plaintiff, defendant, both the government and the defendant, and I will take everyone's concern into account when I rule.
we're way over on time, but I have to ask about the ruling in California today. Gay marriage, no. Prop 8 valid, it stands, but the 18,000 couples who got married in that window where they could get married, their marriages remain legal. What do you guys make of this? I'm trying not to say splitting the baby decision. What do you make of this decision?
Well, which is precisely why this issue is going to really end up before the Supreme Court of the United States. I mean, look, the fact of the matter is, on the one hand, it's so problematic, but we're going to uphold it. And I think for the folks who basically say that there is legislating from the bench, I think this opinion really speaks to that. Because the fact of the matter is, if it's so unconstitutional, the folks have essentially had Prop 8, then get rid of it completely. So that's essentially why I think it's going to ultimately appear before the Supreme Court of the United States.
It may ultimately reach the U.S. Supreme Court, but the justices are not eager to take it on yet. They passed on a gay adoption case from Florida. They've passed on the don't ask, don't tell issue, and so it'll be a few years before 9 justices have to
why
make
the
a decision.
hesitancy? Why the reluctance?
Oh, I think they recognize that it's very politically sensitive, and they prefer for the issue to, as Chief Justice Berger used to phrase it, percolate in the lower court.
There's a lot of percolating going on.
Ken Jost covers the Supreme Court for Congressional Quarterly. Christopher Metzler is a law professor and scholar at Georgetown University.